Delayed TBI lawsuit in New York. Know your rights. Attorney Andrew M. Stengel. Many brain injury victims walk away from an accident believing they are fine. You may feel shaken, sore, and anxious, but the worst of it seems to have passed. Then a day or two later, the real picture emerges. Headaches set in, sleep falls apart, focus slips, light feels harsh, small tasks leave you drained. That delayed pattern is often how a traumatic brain injury or TBI first appears, and it can complicate a delayed TBI lawsuit in New York. Insurance companies look for every gap in your story to challenge the connection between the accident and your symptoms. Understanding how these delays happen and how to protect your health and your lawsuit can change the outcome of your case. Why TBI symptoms are often delayed. Your brain does not always respond to trauma in an obvious way. Some people lose consciousness at the scene, many do not. You may answer questions clearly, refuse an ambulance, and go home, only to realize later that your thinking, mood, and stamina have shifted. None of that means the injury is imagined. It means the brain is reacting on a different timeline than the rest of your body. Adrenaline often masks symptoms in the minutes and hours after a crash. So can obvious physical injuries that demand immediate care. Neck pain, back pain, fractures, or visible wounds may dominate your first emergency room visit while cognitive and emotional changes go unnoticed. Furthermore, some people need time before they recognize what feels different. Others do not notice a memory problem until they return to work, try to drive, or manage the same responsibilities they handled easily before. Because of this, people outside the medical world often misunderstand TBI cases. A person may look normal, speak normally, and still struggle with headaches, light sensitivity, slower thinking, and irritability. Absence of obvious distress at the scene does not disprove a TBI. Rather, it simply means you and your lawyer must document the case carefully as symptoms emerge. How insurance companies exploit the delay. When there is a gap between the accident and the clearer appearance of your symptoms, insurers treat it as an opening. Their typical argument is that real injuries produce immediate dramatic complaints. Adjusters may point to a normal emergency room note or a clean CT scan. Additionally, they seize on any short delay in specialist care as if those facts end the conversation. However, none of those facts defeats a TBI lawsuit on its own. Instead, these arguments simply hand the defense points to press aggressively. Insurance lawyers also prefer to isolate individual facts instead of examining the full timeline. They may zero in on one record where you denied headache while ignoring later records that captured the worsening picture. For example, an adjuster may argue you recovered because you returned to work, even if coworkers saw mistakes, fatigue, and mood changes every day. In a delayed symptom case, insurance companies usually win only when your story stays incomplete. This is why credibility and consistency matter so much. Cases involving a TBI with delayed symptoms become strongest when the medical records, family observations, and work history align. Those sources should all show the same arc. An accident happened, symptoms emerged, daily life changed, treatment followed. When those pieces align, the delay becomes a fact you can explain rather than a weakness that controls your case. Steps to take when brain injury symptoms appear later. If symptoms begin days after you left the accident scene, do not ignore them. See a doctor right away. Tell your doctors exactly when the problem started and how they are affecting your life. Describe specific changes rather than vague feelings. For instance, tell them you forget appointments, get lost in routine tasks, snap at family, or need a dark room to recover. Vague phrasing such as feeling off leaves too much room for doubt. Beyond that, keep a practical daily record. Daily notes about headaches, dizziness, sleep disruption, confusion, screen intolerance, missed work, and family concerns can become valuable evidence later. Loved ones often notice the changes before you fully grasp them, so their observations matter too. Sometimes neuropsychological testing, therapy notes, and employer records help show how the TBI affected real functioning across weeks and months. Most importantly, follow through on treatment. Evidence fades quickly in New York, and insurers move fast. The sooner your medical chart reflects what is really happening, the stronger the connection between the accident and your later symptoms. Delayed onset does not mean a weak case. It means the case needs careful, organized proof built from real examples rather than labels alone. What New York law requires for a TBI lawsuit. New York law sets real deadlines for personal injury lawsuits, and delayed TBI cases are no exception. Generally, you have 3 years from the date of the accident to file a personal injury lawsuit under New York CPLR Section 214. Lawsuits against the City of New York, the MTA, or a state agency face stricter rules. In those cases, you usually must serve a notice of claim within 90 days. That short window hits hard when your TBI only becomes obvious weeks or months later. Additionally, New York auto cases fall under the no-fault insurance law and the serious injury threshold in insurance law, Section 5102D. Your TBI can meet that threshold, but you must be able to prove it with objective medical findings. Such proof includes neurological exams, imaging, neuropsychological testing, and consistent treatment records. Without that evidence, the carrier can argue your injury does not clear the threshold. Such a ruling blocks your recovery beyond basic no-fault benefits. Because New York is so strict about deadlines and evidence, delayed TBI cases demand early legal guidance. Waiting to see if symptoms get better before contacting a lawyer often costs you time you cannot get back. A New York personal injury lawyer can preserve evidence, coordinate with your doctors, and build the proof the law demands. Talk to the law firm of Andrew M. Stengel, PC, about your delayed TBI lawsuit. If you suspect a TBI that surfaced days or weeks after your accident, act now. Delay should not stand between you and the compensation you deserve. The law firm of Andrew M. Stengel, PC, has the experience New Yorkers trust for serious injury cases. We will help you preserve medical evidence, deal with insurance adjusters, and build the case that connects your symptoms to your accident. Contact us for a free, completely confidential consultation. Email info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.